I'm Don Kerwin. I'm with the Center for Migration Studies, and I'm here today with an expert panel, Charles Kamasaki, Susan Timmons, and Courtney Tootie, to talk about a report that they've written, and it's called Immigration Reform and Administrative Relief for 2014 and Beyond. Maybe we could rename it 2015 and Beyond, now that I think of it. But, and the report was written on behalf of the Human Resources Working Group, which Susan and Courtney co-chair of the Committee on Immigration Reform Implementation, which is also known as CIRI, by the acronym CIRI, so we're going to talk about CIRI today. And Charles is one of the three CIRI co-chairs. We have copies, for those here, copies of the report in the back of the room, and it's also available online through our Journal on Migration and Human Security, which you can also subscribe to for free, so we'd encourage you to do that. Before I formally introduce these three authors, I thought I'd take a few minutes just to set the stage for the report. And you know, for many years, I think, by way of doing that, there's been an awful lot of public skepticism about, can the federal government actually do what they're supposed to be doing on immigration, on the enforcement side or on the benefits side. And of course, politicians have taken up this theme very strongly in the context of immigration enforcement. The most common expression that we always hear is, we're still not enforcing the law, the US still isn't enforcing the law. And that ridiculous premise actually leads to the argument that we can't have broad reform actually until we secure the border, which is usually defined in kind of absolute terms as not letting anybody pass through. The federal government's performance in adjudicating immigration applications and petitions has also been an issue over the years. And the issue there when it comes to legalization is that USCIS basically adjudicates about 6 million applications per year, and these big legalization-related programs add huge amounts of work to the volume of cases that they handle. And I think this issue was prominent at the outset of the Deferred Action for Childhood Arrivals program, which was instituted in 2012, and it arose again, the concern anyway, with the President's announcement in November of the DAPA program and the expanded DACA program. And of course, the issue comes up a lot in the context of comprehensive immigration reform and those conversations which have taken place over the last 10 years. And I should say it's a concern of service delivery and immigrant advocacy organizations as well. And these concerns are at the heart of what's really an excellent report which we're featuring today, which details what it would take in terms of staffing, in terms of resources, in terms of use of effective models, and mobilization of communities to do this work successfully on a community level. How would you implement on a community level a large-scale legalization program, whether it was administrative or legislative? And you might ask, why is this issue important, particularly now when it doesn't look like there's going to be comprehensive reform until at least, you know, after the presidential election, and the expanded DACA and the DAPA program have been stalled in the courts? And I think there's two main reasons why this is a particularly relevant report and a timely report. The first, it's important because there are no other viable or good options related to the unauthorized other than a legalization program. Okay, that's just a fact. And really, it's either rank stupidity or political opportunism at its worst to suggest that somehow it would be good for the country to try to deport 11 million unauthorized immigrants and their US citizen children, which presidential candidates are suggesting would be a good idea now. And why? Because, I mean, let's just take a look at the unauthorized population. 4.4 million family members of US citizens or lawful permanent residents whose visa petitions have been temporarily approved. People that have played by the rules, that are waiting in long backlogs, often decades-long backlogs. So of the 11 million unauthorized, that's 4.4 million. 3.9 million parents of US citizens or lawful permanent residents. 3.9 million. 1.9 million persons, we're talking about again the 11 million unauthorized, 1.9 million who have been here for more than 20 years. Really? We're going to deport those people? I mean, it's crazy. And 6.6 million who have been here for 10 years or more. 1.5 million brought as children who would qualify for the DACA program and the DREAM Act. And of course the unauthorized include a disproportionate share of the US workforce as well, more than 5%. So ultimately there is going to be a legalization program. That's point number one. And the second reason that this paper is timely and important is because there's a massive amount of legalization work that can be done and in fact needs to be done and is being done right now. A CMS survey, which I think is also available in the back of the room and in that journal, from last year conservatively estimated that 14 to 15% of US unauthorized residents were potentially eligible for permanent legal status, even absent any kind of administrative reform or legislative reform. And subsequent work by the New York Mayor's Office for Immigrant Affairs, which is here today, suggests that this percentage is likely far higher, and I believe that that's true as well. In addition, as of June of this year, only 243,000 of the 664,000 granted DACA had renewed their applications. This represents about half of the people that were eligible to renew their applications. And in addition, 500,000 were projected to become DACA eligible, just age into the DACA program between 2002 and 2012. And of course, the expanded DACA and DAPA program cover something like 5.2 million persons, and we're very hopeful that those are temporarily stalled and will ultimately become effective. And finally, we know that there's 8 million lawful permanent residents who are potentially eligible to become US citizens, and their naturalization will certainly lead to additional legalization opportunities for unauthorized persons. So there's the point is that there's lots of work to do right now, and all of this work would contribute very significantly and will contribute to a broad legalization program when the time comes, including the DAPA and expanded DACA program. Won't go on for too much longer, I know, but let me just say that for many years now, charitable legal service agencies for immigrants, other service providers, and community organizers have been planning for implementation of a legalization program. These initiatives became far more organized and far more sophisticated with the DACA program and the establishment of this terrific CIRI network. This report that we're going to feature today is a report that has long needed to be written. I can tell you that it involved lots and lots of work and was a real labor of love, although I think the report is probably loved more now than it was when it was in the development stages. But nonetheless, it's not only a very thoughtful guide on what needs to happen, but it demonstrates really the increasing sophistication, coordination, and productivity of the immigrant services and advocacy community. This community is not only advocating for reform, but very conscientiously planning to make any legalization program that happens a success. And so we're very delighted today to have the authors of this report with us. And they are, as I said, Susan Timmons. Susan is the Associate Director of Practice and Professionalism for the American Immigration Lawyers Association. And again, she's a co-chair of CIRI's Human Resources the working group which produced the report. And then Courtney Tootie, who serves as managing attorney, who's charged with capacity building, which is extraordinarily important right now, at World Relief. And she's the other CIRI Human Resources co-chair. And Courtney, I think, will be walking through some of the report's findings. And we're delighted, too, to have Charles Kamasaki with us. And Charles is a senior cabinet advisor for the National Council of La Raza, a fellow at the Migration Policy Institute, and for present purposes, most importantly, I think, a veteran of the nation's last large-scale legalization program, the Immigration Reform and Control Act of 1986. Charles is going to speak on the implications of the report, and I think Susan will speak a little bit on CIRI's history, structure, and the process that led to the report to lead us off. We're not in a rush here. We don't have a huge group here, but we have a very, very good group. And the report deserves careful examination. And we'd like to reserve some time for questions and a good dialogue at the end. So I think that the speakers will probably speak for 10 to 15 minutes each, and then we'll have a discussion with you all. So thank you very much.
Good afternoon, everybody. I wanted to take a few minutes to talk to you guys first about the history and background of CIRI and kind of how this collaboration developed, who it includes. And I will say first that the origins of CIRI began with one of our very tenacious colleagues, Larry Kleinman, who is a CIRI co-chair. He has been working for years in the farm worker community in Oregon, as well as with the Fair Immigration Reform movement. And he and others began to really reach out and talk to a lot of us who are affiliated with national organizations that have national networks and the immigration advocacy and service provider community. And so in 2012 and 13, these early meetings began to take place, and really we were acknowledging that immigration reform was on the horizon, or so we thought at that time. And that we, the field, the immigration advocacy and provider field, would really need to be ready. So in June of 2013, a small coalition of national immigrant rights groups planned the National Legalization Planning Conference that took place in St. Louis, Missouri. And I think some of you in the room were there with us. The participants at this meeting represented a great cross-section of national organizations within the immigration nonprofit world. So we're talking about academics, community organizers, faith-based groups, labor, immigrant rights groups, legal service providers, and members from my own organization, AILA, so the private immigration bar, technology specialists, and then also folks involved in philanthropy who really wanted to hear what we had to say and what we were bringing to the table. And so our goal, this goal of this group that later became CIRI, was really to get all of those players talking. And we talk about it in the report, and I think Courtney will go into a little bit later, we want to focus particularly on non-traditional players who maybe haven't come together and been a part of this work before. And so that's a really interesting lens through which we've really dug into this. So the core group that convened at that conference continues to meet monthly by phone and quarterly in person to move this work forward. And there were several working groups that were developed at that convening that have been in operation since that time. And the Human Resources Working Group that produced this report is one of those. The others, just for your information, are advocacy, training and technical assistance, regional collaboration, technology, and communications. So in the months following the conference, it became clear that we really had to solidify our collaboration. And so we changed our name to the Committee on Immigration Reform Implementation, or CIRI, and that group was really born. And for the rest of 2013 and then in early 2014, we were eagerly anticipating Senate Bill 744, but after it came in April of 2014, and the months went by and it didn't seem to be going in the right direction legislatively, it became clear that though no comprehensive immigration reform legislation was forthcoming, our work could not stop. And so we began to pivot a little bit towards the potential for administrative relief. And in the months before November 2014, as we eagerly anticipated the president's announcement, he promised that he would be taking executive action on immigration, and we continued to meet regularly to discuss what those implementation strategies would look like. Perhaps with a different population, with different numbers, what would those numbers be and mean? And we're going to talk about that in a little bit. But we were really shifting our focus at that time. But despite that shift, we believed, and we believe today, that the same basic structure would be necessary for the field to really succeed. And so we began to look back on our experiences, certainly with IRCA, but also more recently with DACA in late 2012 and 2013 as a benchmark. And we knew that DACA had really stretched the capacity of the field, and that was only 1/5 of perhaps the numbers that we would be looking at under an administrative reform scheme, and the scheme that eventually came out. So we knew that there was still a lot of work to be done. In late November, on the 20th of November, President Obama announced that his administration would make modifications to immigration policy. And immediately, the Department of Homeland Security issued a series of memos to make these changes to removal priorities, secure communities, deferred action for childhood arrivals, other deferred action, provisional waivers, parole, and others. So in general, those reforms fall into 3 categories, and they're changes to enforcement policy, the expansion of deferred action, and then changes to our overall legal immigration system. So the other thing that CIRI did that was really important as a first step was to immediately launch the Administrative Relief Resource Center, which can be found at www.adminrelief.org. You guys may be familiar with this website. It houses not only a summary of the provisions that were announced under administrative relief, but all kinds of other tools, video summaries, webinars, PowerPoint presentations for community organizers to use, an eligibility screening tool, and all of these tools were designed and worked on by all of the different members in the CIRI network so that community organizers and folks out in the field could really make them their own, and could use them for whatever information and outreach they needed to do. In February of this year, in 2015, CIRI brought stakeholders together again for the Ready America conference, and some of you may have also attended that conference in the Washington, D.C. area. And we really wanted to continue this conversation and really get serious about developing the field and pointing them towards resources, encouraging collaboration, doing whatever we could as a network to really continue this movement forward. And although now the President programs are currently on what we kind of like to consider a pause, we believe that as a field they will be implemented. And so as Don said, and as Charles will underscore at the conclusion of our presentation, we believe it is still so imperative to continue to focus on building and expanding the field, because DACA really showed us that we just don't have enough capacity for what we're going to be facing. And so that's why we're really thrilled that you're here today to talk to us about this report. CIRI is a collaboration of 27 organizations, the majority of which have national networks. I could tell you all of their names, but there are too many letters and acronyms to count. But almost any player in the national immigration advocacy and provider field and network is part of CIRI. And so I would encourage you to go to adminrelief.org if you have questions or you want to know more about who we are and how we got together. Transitioning a little bit now to the Human Resources Working Group. So it's in this context, this history of CIRI, that we began our work really at that conference in St. Louis in the summer of 2013. And Courtney and I laughed at that first meeting because our charge seemed to be to figure out how we were going to staff all of the projects that all of the other working groups were coming up with, our technology friends, our regional collaboration friends, training and technical assistance. So how are we going to get the manpower to put this out into the world? And although that task, as I'm sure you can imagine, seemed really incredibly daunting, our first step was to try to get our hands around the scope of our challenge and the work that was ahead. So what we looked at in order to kind of make those assumptions, and we have to be really honest about the fact that this report is based on a lot of assumptions, a lot of experience, but a lot of number crunching within our human resources group and then within the CIRI steering committee. But we were trying to ask, so what number of individuals are really going to need assistance? Who is going to come forward? And this number changed dramatically from looking at the 11 million when we were talking about legislative reform to more like 5 million when we were looking at administrative reform. And of course, all this happened during the period that we were working together. So who among those 5 million would come forward, and what types of assistance would they want? What types of assistance would they need? Would they need full hand-holding, 6 to 10 hours of intensive individual legal assistance, or could they be helped in a group processing workshop model? And what would that look like? How many legal services workers would it take? Would it be volunteers? Would it be staff? Would it be lawyers? Would it be non-lawyers? And what were the biggest gaps geographically? So all of these questions we were grappling with as we were trying to come up with any sort of answers that we could present, in particular to the philanthropy field, to make people understand what the need was going to be and how to support the legal services providers in the field. And so we began by really reviewing what others had done to start to map the field and what that looked like. And we had a number of goals, and one of those goals was to produce this paper of a national human resources immigration reform plan to pull together demographic information to help with that assessment, to document what other groups were doing to prepare all around the country, other networks. There were state-based networks that had cropped up in California and Illinois and New York and other places. To do a real legal needs assessment, to come up with potential job descriptions, to produce some volunteer coordinator trainings or to help coordinate with those, to think about other innovative ideas, some that had been done before and others that hadn't. So one of those ideas was a legalization corps for new law grads who didn't have current employment. Is that something that we would want to look at? And Equal Justice Works became very involved in our work. Other innovative service delivery models, and we really wanted to be a place to develop those ideas and incubate those models and then propose pilots. And so a tremendous amount of the other work aside from the report is still ongoing, and we really believe that we're a great place to think about and those kind of high-level ideas, new and different delivery models that we haven't considered before. And so the composition of our group was really diverse, actually. Courtney and I come from two very different backgrounds. I represent the private bar. She is a trainer training legal and also non-lawyer BIA accredited reps. But also we had members from the American Bar Association, from Equal Justice Works, Clinic, from the Lutheran Immigrant Refugee Service, what was formerly the Florida Immigrant Advocacy Center, now known as AI Justice, the Hispanic Federation, Chicago Bar Foundation, and also other national funders. So we really felt that even though we were a small group at that conference when we started our work, we had a really diverse group of individuals working and thinking about these challenges. In terms of our process, as I said before, a lot of this report is really based on assumptions, and I think we're pretty upfront about that. But a lot of it is based on judgments of prior experience, mainly IRCA and DACA, and of course Charles was wonderful to be our IRCA expert and can give you the lowdown on anything that happened during that time if you are so interested. Courtney will get into the number crunching, but the initial DACA program instituted in 2012, as I mentioned, really now has already stretched the capacity of the immigrant serving organizations to their limits or beyond. And so the possibility of full implementation of these new programs of DAPA and expanded DACA is going to present a formidable challenge for these organizations, which is why we are focusing so heavily on capacity building. In our paper, we seek to provide a roadmap for this service delivery for partners in planning for implementation of these programs, and then with an eye ultimately to broad legislative reform. But we recognize that that may be a goal for a little bit further out in the future than we would have hoped. But specifically, we're really looking at the funding and human resources that the field is going to require to implement these programs. And so we collected a lot of information from what few published sources there were, which was not a great deal, but also working group members' personal and professional experience. And although our members may have had diverse interests and views on the question of how much legal service do immigrants need, looking back at those, do we need a Cadillac service delivery model or do we need a group processing service delivery model? We all had some common desires, and those were to maximize the numbers of qualified people to successfully apply for any new programs or existing programs. We had a shared interest in preventing exploitation by unscrupulous service providers, otherwise sometimes referred to as the unauthorized practice of immigration law. And we tried to come up with a blend of different models for these different estimates. And you'll see what I mean by the blend of models when Courtney talks a little bit about our numbers in a few minutes. And so we produced this initial calculation and drafts that were reviewed by the full steering committee in this very elaborate Excel spreadsheet that had a lot of assumptions that helps us to get to those numbers. And we looked at if expanded DACA and DAPA were implemented, ultimately we estimate that if the total of 5 million people are eligible, about 1.08 million will require extensive application assistance. And that a little over 1 million number generates the need for approximately 3 times more full-time staff that are currently in the field, which is pretty enormous, right? When we think about these numbers, 11 million, 5 million, so 1 million seems actually pretty small, right? But it stretches the capacity incredibly, and so that's our kind of overall challenge, and I think what we want to say to funders and to the field, like our challenge to that group. And then we came to a place where we had all this knowledge, but we didn't really have a place to share that knowledge. And that's where Don came in and really encouraged us to seek publication of this paper through CMS, which is what brings us here today. So that's going to conclude what I have to say, but I really just wanted to start out by giving you that background and some context for how we got to the findings that Courtney's going to present.
So one thing that I wanted to underscore that Susan just said is the diversity in this field and the players who are coming to the table and the organizations that are involved. Traditionally, the nonprofit legal service world saw services as one-on-one, meeting with a client with the ultimate goal of submitting the application. That is still the goal, but with DACA, we've seen a lot more organizations come to the table who weren't traditionally involved. That has produced a very diverse field of people who are here to help. That has made our job very difficult in trying to prescribe how many people are needed for this diverse world of work. So when we're talking about traditional nonprofit legal services, we are still talking about the one-on-one services, but there are a lot of other ways that people are meeting those needs. One is through group processing workshops that Susan mentioned. There also will be a lot of technology involved that we have seen a little bit with DACA and hope to see with expanded DACA and DAPA. That will help those who aren't necessarily able to come in for the one-on-one service do it on their own. So there are a lot of different factors that will be playing in to the numbers that we are going to talk about today. And again, I would just underscore it's hard to prescribe these numbers for such a large group of people, and so many different activities, so take them for what they are. So first, the assumptions that we were working with. As Susan mentioned, we are assuming, based on all of the resources that we've been seeing, that there will be a group of about 5 million people who will be eligible for some kind of relief through this program, whether it's expanded DACA or the DAPA program, the Deferred Action for Parents of U.S. Citizens and Lawful Permanent Residents. Based on the history that we went through with IRCA and DACA, we took kind of the upper bound and the lower bound of those who applied during those programs. So during 2 years between 2012 and 2014, about 60% of those eligible for DACA applied. And we used the 60% as our lower bound. And then with IRCA, about 75% of the people applied, and we used that as our upper bound. So of that 5 million people, 3 million would be the 60%, and then 3.75 million would be the 75%. So within that, again, based on the history with DACA and IRCA, we felt that about 40% of those people would need some kind of help from nonprofit legal service providers. And 80% of that 40% would need low-cost service and would not be able to hire an attorney. And so they are from the low-income population. So what we came up with there is that 960,000 to 1.2 million would be low-income people needing service from nonprofit legal service providers. And as Susan mentioned, the midpoint that we operated with is the 1.08 million. And that was kind of where we set our middle ground for a lot of the numbers that we created. A couple of the other assumptions that we operated from is based on past experience and a lot of the people in the field now. We felt that between 4 and 8 hours of time is necessary for each case. And that's not necessarily just the time where somebody is sitting down with the form and with the client, but a lot of other services go into that, such as outreach and mass communication, case management, things like that. So that's why there's such a wide range of time necessary. Again, those are kind of how we felt median times were. Some cases will take less time, others, the more difficult ones, will take up to 10 to 12 hours. And then finally, we operated on the assumption that one full-time employee is about 1,650 hours per year. We took into account vacation, time off, other responsibilities, and felt that each person would have about 1,650 hours to devote towards legal services per year. So getting into some of those calculations, with the 1.08 million people requiring an average of about 6 hours per case, that came out to about 6,480,000 hours, which divided by that amount of hours per year gave us 3,927 more FTEs that are necessary to implement the DAPA and expanded DACA programs. Now, that would be full-time employees who are just working on those two initiatives. The reality of this work is that most of the people who are engaged in it are overburdened and already overscheduled with the amount of cases that they have. We looked into the Immigration Advocates Network directory as well as the Board of Immigration Appeals roster to see what the current capacity is and really who is out there in the field right now. Through those two directories and kind of evaluation of the field for legal service providers. So this is attorneys, BIA accredited reps, paralegals, paraprofessionals, volunteers, there is a number of about 4,687 people. That number has actually changed a little bit since the report was published, and hopefully it will change more and increase. But that's kind of where we based our numbers off of. And those are roughly 4,000 people in about 1,000 organizations. So, taking into account the amount of responsibilities that all of these professionals are dealing with, we felt that each person would be able to give no more than 25% of their current time to a new initiative, expanded DACA, DAPA, or comprehensive immigration reform if we get it. So based on that and the number of hours per year that we have, there's really only about 1,200 people who are able to fully commit to this time. About 2 million hours of all of those 4,000 people can be shifted over. And really that shift can only happen with proper front-loaded funding, because most of them are already stretched thin and have so many other responsibilities. It is really difficult for people to just drop those responsibilities and move over to something else. We saw this a lot with DACA. Many of the service providers who were working on DACA at the end of it said they were overworked, didn't have enough time, there was never enough staff in order to meet the need. So proper front-loaded funding is really necessary, and had there not been an infrastructure in place for DACA, then I'm sure the reports of people being stretched beyond their means would have been even greater. So right now there is a current capacity of nonprofit service providers. Law schools are also another place where people want to get involved, but there are certain restrictions like credits and professors and things like that. And similarly, the private immigration bar and pro bono non-immigration bar have said that there will be some involvement, but it won't necessarily be in the form of just being able to drop everything and give low bono or pro bono service. So because of this, there has been a lot of work and examination into what is known as nascent capacity, which are organizations who are primed to get into immigration legal services, but don't necessarily offer them currently. So a lot of these organizations are libraries, job training, and workforce development, domestic violence shelters and programs, ESL, African and Caribbean-led programs, labor unions, faith-based organizations, and a lot of these, we have seen them start to get a lot more involved in the past several years, especially when it comes to DACA, and they have been able to rally around that and become Board of Immigration Appeals recognized and accredited, so now they too can offer legal services like any of the other nonprofits in this work. So the money, and this is kind of where it starts to get very, very tricky. So again, because we are working with such a diverse field of people and demographics and over our entire country, it was very hard to predict how much each of these people would be paid. So we kind of took three very broad salary pools of $50,000, $75,000, and $100,000, and worked from the 4, 6, and 8 hours that it would be necessary to do each of these cases or to complete each one of these applications. And I am not going to go through all of the numbers of how much things could cost, but really it ranges from roughly $116 million for 960,000 applicants at 4 hours each at a $50,000 salary, all the way up to roughly $581 million 8 hours per application, 1.2 million applicants at $100,000. And really, it's going to be somewhere in between. So the midpoint that we have used for some of our other calculations is a 455,000. So it's a big number, but really it's not that big of a number when it comes down to it. And another thing with immigration legal services that is actually very helpful in the nonprofit realm is the fact that nominal fees can be charged. And in our opinion, should be charged because they really do help to sustain the programs and offset some of those costs that come with providing these services. So again, we took a range of prices ranging from $100 to $200 per case, and the midpoint of that being $150, and really applied those to the potential applicant pools of the low-income applicants that we would be dealing with to come up with a rough estimate of how much we would be able to offset the cost by charging nominal fees. The number that we kind of worked with is 162 million would be able to offset some of those costs. However, I would say that with the caveat of these numbers really assume a lot of collaboration, a lot of diversity when it comes to who is doing what, and really this collegial atmosphere of working together. Without that, the costs will go up, and the need for full-time employees and the number of full-time employees needed will go up. So we believe that with the amount that can offset the cost, that anywhere in between 34 million and 132 million is what the funding gap will be. And we kind of took the 83 million as the midpoint of that, with this is the gap that we need to fill, and this is what is needed in order to ensure a highly coordinated field will be able to respond to a large-scale legalization effort. That 83 million seems low, but again, it does assume that coordinated effort, and it's not going to be every case filled on a one-on-one basis for 8 hours. So there will be a lot of creativity and innovation that's necessary in order to respond in that way. And with that, I will turn it over to you.
Even for those of us who have played around with these numbers for a long time, that was a stunningly clear presentation of our assumptions, so thank you, Courtney. My job today was to offer some caveats and discuss why getting this right is important, not just for the field, and obviously not just for the immigrants, but for the country. Discuss a little bit about the value of the analysis, even with these caveats and even in a post-litigation scenario, and conclude with a little bit of a call to action. But first, I thought it would be useful to provide some acknowledgments. In addition to those of us here, a number of other people contributed to this paper. Carrie O'Brien, who was mentioned earlier from Equal Justice Works, really pulled together the original spreadsheet that we've really used and reworked over and over again. Jack Holmgren from Clinic, who happens to be here, was not just a cheerleader for this project, and believe me, we needed cheerleading, but also applied his own vast experience to help with early drafts of this paper. You know, Don Kerwin, as Susan mentioned, really first saw the potential of this report as a useful paper, but he was also extraordinarily helpful as an editor. And it's really rare in this field, or in any field, to have someone who's both an expert editor and substantively so knowledgeable that was able to turn really kind of a mess of a draft into a really highly structured, I think, effective paper. And finally, Amelia Collins on the NCLR staff, who reworked and worked various calculations and also prepared the paper for publication with checking sites and formatting sites. So let me start with some caveats. As everyone has already acknowledged, in a paper like this, all of the assumptions should be interpreted with caution. They're all deeply sensitive to even very small shifts in assumptions. So a little bit of a shift in the number of hours per applicant, or the number of applicants, or the cost of FTEs becomes very, very important. Some of those factors are within the box, as it were, of the calculations we give you, but some of those are also outside the box. And so there's been a little bit of a discussion here already about the models matter a lot. So if, for example, in a processing situation where many folks are assisted principally through a volunteer, and then with a case review at the very back end of the process, we might be talking about only 1 or 2 or 3 hours per case. Obviously, in other situations where senior attorneys are required with complicated cases, we're bucking up against that 8-hour higher end limit. So, you know, again, just to emphasize, the numbers are highly, highly sensitive. Still, we believe even if the numbers are wrong, the framework provides a model through which, based on experience, we can adjust those assumptions one way or another and end up with at least an order of magnitude estimate of what the field needs. Second point, why is getting this right important? And the evidence, I think, is pretty clear on this. You know, what are the costs and benefits of getting this done right? And obviously, the human costs. Every eligible person not legalized will have more limited opportunity, live under the constant threat of deportation and family separation. There's also a societal cost that every eligible person not legalized is one more human being living outside the scope and protection of the law. And there is, finally, a significant economic cost and benefit, cost to getting it wrong and benefit to getting it right, especially since all of the government costs are paid for by user fees themselves and fees to the government, and between 2/3 and 3/4 of the nonprofit infrastructure costs are going to be borne by the applicants themselves in terms of fees to nonprofits. According to the Center for American Progress, and this is on page 301 of the study, of the report, or the paper, the benefits to society at large are huge. A cumulative GDP increase of $230 billion, income increases of $124 billion for all Americans, not just the immigrants themselves, creation of 288,000 new jobs for all Americans, and contributions to the Social Security fund of more than $41 billion. And just to quote from the paper, the prospect of accruing such enormous societal benefits at literally no cost to the taxpayer represents a rare opportunity for this country and for all Americans. We think these benefits accrue even in this highly certain situation with respect to the litigation. So if one were to assume for a moment that DAPA and expanded DACA programs don't occur, there is still a need for immediate additional capacity to assist 3 discrete groups, as we conclude at the end of the paper. More than 500,000 people eligible for DACA that have not yet applied, that's not even counting those who need to re-up. Over 400,000 people age eligible for DACA but have not yet met the educational requirements. And as Don alluded to, at least 1 million, and probably many more, that are eligible for other forms of relief. So using the same methodology that Courtney walked you through, we end up just to serve those populations with a net funding gap or a capacity gap of almost the same size as we produce in this paper of about 79 or 80 million. And that's likely to be especially true because much of the population we're talking about outside of DACA and DAPA, that is to say people who are eligible for other forms of relief, probably will require at the higher end of the 4 to 8 hour estimate of time per case. Finally, conclude with what we can do now. The litigation delays have been harmful to the program, but have given the field the rare luxury of having some time to plan and prepare that we weren't counting on originally. We can, as the HR group at CIRI are doing now, testing some innovations, establishing some relationships and linkages that we would not otherwise have had. But since we live in a, on the one hand, on the other hand, world, one of the things I would note is a lot of the shifted capacity that our paper assumes is pretty much already spoken for through the response, really extraordinary response of the nonprofit and pro bono legal communities to the crisis on unaccompanied minors that started a couple of years ago. It's not clear to me, or let me put it the other way, it is clear to me that much of the shifted capacity that we assumed in this paper is already spoken for through those efforts. But in any event, the main point we want to conclude with is even in this post-litigation scenario, there are enormous benefits to society, a continuing need for society to invest in building capacity to serve this population with literally the same urgency, if not obvious in the headlines, should be obvious in the data. Investments are still required by the nonprofit sector, by philanthropy, by other institutions, and by the immigrants themselves. And I would just conclude with those folks serving or funding or operating in local environments. One way to use this paper is you can use it to accompany a tool that CMS has published previously that estimates with some level of granular detail populations that may be eligible for various forms of relief down to quite small local areas. So one can combine those CMS estimates to estimate the total populations eligible and then use this paper to try and apply this model to those and try and figure out what the specific nonprofit sector capacity might be in that particular area. So I'll conclude there and turn it over to Don.
Thank you. That was really terrifically clear presentation of a really complex paper. Charles did some of this, but I also wanted to recognize somebody else that's been very involved in the CIRI initiative, and it's Michelle Sardone who is with us, and she's actually coordinates all of the CIRI groups. So she's the taskmaster, but she's a lot more than that too, kind of the vision and the organizer of all of the groups that are involved in this work. Let me start with just maybe a couple of observations, like listening to you three, and then we'll open it up for questions. One is, I'm struck, and I said this in the outset, is how sophisticated the field has become. You know, I mean, it's really quite startling, and I think that this is a bit of a milestone. I wonder if you, particularly you, Charles, can kind of reflect on how different it is now, how much more sophisticated, better organized, better planned than it was during the '86 Act. And then I'm struck too that legalization period and legal status is really as much of an access to justice issue as it is an issue of trying to get Congress to pass something, the Obama administration to do something, because there's so many people out there that are actually eligible for something and don't know it or haven't pursued it, or do know it and haven't pursued it. for whatever reason, likely because they have insufficient information or they don't have legal counsel or whatever, people pushing them to do that, that we really do have like a critical mass of people that we can create a legalization program for now, if only we get the access to justice piece right. I'm struck with the Moya survey actually found, they interviewed 588 different people, screened them, and they found that 38% of them were eligible for either DACA, DAPA, and another form of immigration relief, or just another form of immigration relief. That's 38% of 588. We found 14 to 15% in our survey, but I think that it's probably much higher than that. So let me just make those 2 points and maybe ask you, Charles, to talk about how the field's evolved, and then also ask Courtney and Susan to talk about this issue of the increasing sophistication of the access to justice issue.
Well, obviously the field has evolved. I will say maybe there are 2 big lessons from the IRCA period that I think the field has learned and gotten beyond. One was really led by what's the precursor to Clinic, what was then MRS's legalization program at the U.S. Catholic Conference, Migration and Refugee Services at the U.S. Catholic Conference, really did quite detailed original estimates of the numbers of people likely to apply and tried to construct a model to provide services to them. I think my big lesson coming out of that program, where maybe 40 NCLR affiliates participated in legalization, is we couldn't only look at it from a, say, bureaucratic model of us building capacity. We also had to recognize there was a market out there, and that people would forum shop. They would go to the place that they thought provided the best service. They would often go to places that we didn't think were qualified, but if we didn't have the capacity to serve them, then we were hardly in a position to stop them from getting other kinds of services. So I think this Human Resources Working Group has incorporated a lot of that real-world knowledge to try and do the quote-unquote bureaucratic work, but much more grounded, I think, in reality. I guess the second point I would make around sophistication is, it's not just sophistication, I think, from the services side, but I think our demographic estimates seem to be much more solid. At the time of IRCA, some people were talking about 10 million people qualifying for legalization. No serious demographer thought that, but those numbers were out in the atmosphere. So I think we've gotten more precise, and I think the field has gotten more rigorous, both on the supply end of demography, and then also on the demand end of estimating the number of people applying, as well as the supply end of figuring out what we as a field could actually do. One final point I would make about the people with other remedies. We are facing a chicken and egg problem, which is, some might ask, well, why aren't we doing outreach campaigns to inform people that they have other remedies and to try and get them to come forward? And the answer is, people who are already overburdened aren't looking for more business. So I do believe we are in a position to do much more significant outreach and to inform a lot more people of the potential remedies they may have, but we've got to build up capacity first.
And I think on that access to justice point and the people with other remedies, I think it's somewhere between that 38% and 14 to 15%. As I've heard that 25% is a pretty standard average of folks that come into any legal service provider seeking out DACA or other types of new administrative relief. And But just as a general matter, this is a little bit of an aside from what we're talking about today, but I have been, on Ayla's behalf, really tremendously involved in working on the border with family detention issues over the past year. And the reason I bring this up is it's become completely clear to me, which something that was clear in the abstract before, but certainly is now, that if an immigrant is touched by any kind of service provider, even if it is a non-legal service provider, providing just basic information, that they have a better chance to tell their story, whether it's in front of an immigration judge or a USCIS asylum officer, whoever it is, just by having a brief conversation and a very light touch. The cases that we have worked with, I mean, something like 90% of the women that we've worked with over the past year are qualified for asylum. Now, whether or not they win their asylum or withholding claims is in some cases another matter. But we have won most of the cases that we've taken to trial, and that just really illustrates to me that if you are someone who is out there in the shadows and you have any sort of interaction with a service provider at almost any level, you're going to be better off than you were before that conversation.
Let me just ask, sorry, one more, and then maybe we could start getting people to line up if they have questions. And that is, I'm also impressed with the, there used to be kind of a tension in the field between attorney-driven models of legal representation and also including within that the Board of Immigration Appeals recognized agencies, which are accredited representatives but often have attorneys working for them. And then the community groups, which are extremely important but don't necessarily do legal work. And I've been impressed with kind of the way in which those two communities have come together at CIRI and recognized kind of a division of labor. I mean, it's a little bit, it's still not 100%, easy, but nonetheless, there's this real commitment in terms of both need each other in the kind of it's even modeled within the paper, I think, in a really interesting way. And I wonder if maybe one of you could talk about that. Who should be doing what and how you've kind of conceptualized that in terms of the models, in terms of the papers, or just in terms of your own thinking?
So I think that, as was mentioned a little bit during the discussion, there are a lot of different activities that actually go into the provision of legal services. And I think in the past few years, and really with the creation of CIRI and the camaraderie that has been created through CIRI, there's been a lot of working together in those types of actions that wasn't there before. One model that has come out of it is known as the Community Navigator model, and it allows for community organizations who aren't necessarily recognized by the Board of Immigration Appeals or don't have lawyers on staff to do some of the upfront work, the outreach, the communication, some of the education and screening, so that a lot of the clients are more prepared when they end up going to see a legal service provider. A lot of these organizations can also do the preliminary screening that then allows people to go and apply on their own if they have one of those cut and dry cases. So there is a lot of collaboration that's going on, and really that's making the field a lot stronger and allowing this group mentality, so we're all coming together to offer services opposed to kind of staying in the silos as we were before.
And I think the other thing I would say about that, being the representative of the private bar, as I often am in the room, is that DACA give us a real interesting experience in terms of that type of collaboration. And so I think there's a little bit more trust that's been built. I feel like I spend a lot of my time trying to explain to lawyers how organizers work and think, and trying to explain to organizers why UPL is a term that is very sensitive to the legal community and why it's important to have people who are authorized to practice, and what the ramifications of getting it wrong are. So I think there's a lot of understanding that has been developed over the past few years. I think there's also an understanding that AILA is a membership organization of about 14,000 immigration attorneys across the country, and even if we, which I think one time we did, just kind of for kicks, like put all of those lawyers into the numbers, it's still not enough. So we're not really in a situation where we're diverting the population that would go to those private practitioners anyway, and I think that they really recognize that that's the case. So I mean, I think it has been very successful, and it will remain to be seen how we work, together in the coming years.
Questions from you all, comments? We have a lot of great experts.
You want us to step
Yes,
up?
please, and please identify yourself,
Okay.
Oscar.
Sure. Oscar Chacon with the National Alliance of Latin American and Caribbean Communities, soon to become Alianza Americas, much shorter name. The first question I have is, after the legalization component of IRCA in 1986, there has been actually a wide range of programs, that benefited, if you add them all up, probably somewhere in the 1.5 million people. I'm talking about the 1991 TPS program, the 1992 DED program, the 1997 APC implementation, the 1998 Honduran TPS, the 2001 Salvadorian TPS, NACARA, ARIFA. Did you look at the experience of actually implementing these programs when you were trying to gather experiences in order to come up with your scenarios? I mean, that would be one question. The second question, and perhaps, one of the most important questions for me, based, what we know now, what would be, from your point of view, the most optimistic scenario to actually getting to implementation of DACA Plus and DAPA? Because it looks pretty murky right now altogether, and I think that this translates into lack of interest by a lot of the immigrant population who otherwise may be excited, that they can apply for these programs. So I'd love to hear, what your best forecast, would be at this point in time in terms of ever getting to actual implementation. And, well, I'll probably ask more if nobody else does, but those are two key questions.
It is true that there have been, and Don has also done a lot of work, probably the definitive work on the total number of legalization programs in this country, including those that you've mentioned. We did look at some of those, or I guess I would say I kind of looked at some of those. Our problem is we don't have very good data on outcomes. So I think Don has done some papers during his time at the Migration Policy Institute that sort of can cite the INS statistics, but not a lot of the sort of substructure data that actually were available for IRCA and to a greater extent were available for DACA. So I guess the answer is sort of yes and no. I do think those were instructive experiences in that, at least to my mind, they did demonstrate you can build nascent capacity into quality legal service capacity relatively quickly, right? So probably when you entered the country, none of the Cadescents except maybe LA were really doing processing on a significant basis, and now they're all doing it on quite a high level. In terms of the optimistic scenario, I don't think it's any secret. You want a decision, Fifth Circuit decision pretty quick. You want a writ of certiorari granted early next year, and a case scheduled for argument as soon as possible in the Supreme Court term. That's sort of the window that we have, and that's the window we're expecting.
looking at the other programs, when we were very cognizant of them. I'll say this, that I think that there's one of the reasons that we really pushed to publish this paper is because the record is so thin in terms of how those programs actually worked. So people had a lot of experience on TPS renewals, on HARIFA, on NACARA, on all of those other programs, but it wasn't memorialized anywhere. It's nothing that you can go access, and it was a personal issue for me because I've been involved in some of the implementation of some of those programs at clinic, and for example, like something that would be akin to this might be the naturalization work that was done to keep people from losing public benefits after passage of IRA that was funded by the Emma Lazarus Fund, and we were heavily involved in that. And we'd done a lot of reports on it, and I actually couldn't find the reports that we'd done on it, and couldn't, is something to cite or look at. And I know it exists, but if you can't find it, it doesn't really exist for the purposes of doing this kind of analysis. So the idea was that we needed to really do a better job because there's a lot of turnover in the field. We go from crisis to actually documenting what we're doing on particular programs. And I think that was the argument for this paper. And we had pretty good, not great, but decent information on the IRCA program, and the DACA program was recent. And so those were the two main programs that we relied on, or that the paper relied on, I should say.
I'm sorry, let me just add one other thing, and your point is really important, and Don's point is really important too. If one, for example, only looks at the NACARA adjudications that are labeled that way in what were then the INS statistical reports, I think the number's like, what, 60-something thousand? We know what the family of litigation and temporary programs and renewable temporary programs and permanent programs that the litany of which Oscar just went through, we're talking about 800,000 to 1 million people benefited. So again, just to reemphasize why we thought it was important to get this paper out now and to allow people to use it as a benchmark to say, hey, these guys were wrong, the real number was this, but at least there's a benchmark to start from.
Other questions we can, yes.
My question is more about, we talked about the division of labor, so following up on Don's question, and we talked about bringing in navigators and joining them with legal services. What is the status right now of the issue, the submitting G28s or not G28s? Because I know during DACA, USCIS said, go ahead if you're doing a clinic, you don't have to put in a G28 as long as you sign as preparer. But now if we're joining this model of navigators with legal services and say the CBOs are providing navigation services at their location, what is the idea of, do the lawyers have to provide a G28, or is it just enough that they're supervising and advising on the legal side?
That is such a tough question, mainly because USCIS has given us no guidance. They promised us guidance about, 6 years ago, 5 years ago, and we never received anything after that statement. And that actually was around, came out right before AILA has a naturalization event, as many of your organizations I'm sure do, AILA Citizenship Day, which is an annual event. And we pushed back and said, we will not hold this event if you make this a requirement, because we're not having individual lawyers who come in to volunteer on a one-day event be required to sign a G28 in most cases for an application that's not even completed. Like, you would never do that in any circumstance in your life if you were, making a signature on a legal document. So I don't think that there's really a clear answer there, to be honest with you, at least not from AILA's perspective and from our reading. When we're doing these types of group processing events, encourage each individual collaboration and organizer or AILA chapter to kind of talk through it and walk through it and what they think is a best practice. In the context of Citizenship Day, some chapters will write AILA Washington, D.C. Citizenship Day event. and not sign a G28, but sign that on the preparer line. So I think that is perhaps one option. I've seen other nonprofit organizations do, a similar stamp like that at group processing events, whether naturalization or DACA or any other type of relief. But I think it's a tough question, and I think we have to push it back on the government to say, you really need to give us clear guidance on this, and by the way, you better be careful what that guidance is, because you could really hamstring the field if you give us the wrong answer.
Yeah, I would just add one other. So after all the happy talk about how we're all getting along, there are some fault lines in the field. This is one of them. The other one, which does relate to this paper, is how do the fees work in a situation where you have a pro bono lawyer helping at a clinic that might be sponsored by one of our affiliates, not to take a real world example, and so who gets the fee? And is it even legitimate for, say, a CBO to charge a fee? Or since it's the actual service is being provided by a pro bono attorney? Those are not all settled issues, but I think they're on their way to being settled in a way that would not have been the case certainly 20 years ago or 10 years ago.
I wonder if I could just jump in on that, because I think one of the things I really liked about the paper is that you were not going for a high-end number for funder purposes. In other words, you were really conscientiously looking at what existing resources were, what existing coverage could be, and you came up with that 83 million gap figure, and you came up with it in one of the sources of revenue were fees. And actually, that is charging fees at all was very controversial at one point, and it's still in some circles fairly controversial. And I wonder if you could talk to kind of your thinking on that. I know very well what our thinking was at clinic many years ago when we looked at this, and it was that these programs weren't sustainable without charging fees. There was no other source of unrestricted monies. Granted, it was only a small percentage of the budget, but fees were crucial to be able to maintain programs and to build capacity. But I wonder if you could talk about that just a little bit. Sorry.
No, that's fine. I think, well, personally, from our experience with the churches, this is an issue that comes up all of the time, because we work with a lot of people who do not want to charge fees. And I think the fees, yes, they do help with sustainability of the programs and allow for a continuation of offering services, but there's also an empowerment piece that comes with it, that the ownership, once a fee is charged, becomes so much greater. And it really helps with the provision of the services, in that if someone is paying even a small nominal fee for this case, they're more likely to show up when they have appointments. They're more likely to bring documents. And really, it helps to bring that ownership of, this is a really important piece of my life that I am helping with. And I think that's one of the things that, besides all of the sustainability and things like that, really is brought to the table with the fees. I will say that in writing this report and this paper, the fees was one of the issues that we talked about the most. In people saying $100 was way too high for the low base, or $200 wasn't high enough. So there's a lot of discussion and disagreement that happens around the fees, but I do think that it's something that is really prevalent and should be encouraged when it comes to these types of services.
Other questions? Oscar, you had 18 more.
I do.
Let me ask you one, and that is, you've run agencies for a long period of time that actually link community groups, community organizing functions, and legal services. How do these, and you feel, I know very, very strongly that the two feed each other and are extraordinarily important to do in a combined way. I wonder if you could talk about how those two things fit together.
Glad to do that. But before I do that, on the question of fees, I have worked actually since the mid-'80s with Latino, community-based organizations, and I can tell you that it was then, and it's been all along, and it remains very strongly. I mean, a source of big tensions. I mean, the whole question of fees. I can tell you so many anecdotes. I mean, that, in Massachusetts, for example, the Department of Education in Massachusetts used to fund adult education programs. English as a second language, Spanish literacy. Eventually, they ended the funding. And when they ended the funding, most groups folded. Most groups closed. We didn't. In Centro Presente, I was there at the time. And the only way we could keep it up was charging. And what we learned very interestingly is that when we began to charge, we couldn't actually handle, the flow of people coming in, as opposed to when we were offering these programs for free. Go figure, as to why that is. But, it made us look good before the community, but among peer organizations, we were always like the little devil, in the community because we were charging poor people. So I think that that's a tension that it's important to acknowledge that it still exists today. I see it in Chicago, I see it in Los Angeles, in Massachusetts, in Houston, etc. On the question of organizing versus providing services, I'm sure that you all here are familiar that many of the Central American, some of the Mexican immigrant-led organizations have actually developed very interesting models combining both. Providing services very often for a fee, and organizing, meaning getting people involved in a lot more than just fixing their particular need from an immigration services point of view. But the reality is that the dominant school of thought, when people think about organizing in the US, continues to be one that suggests that we shouldn't mix, providing services with organizing. And I think that the Central American case in particular shows clearly that that is a false contradiction, and that we need to be more embracing of the idea that yes, we can provide a pretty good quality service and at the same time get people involved in processes that are more complicated than just simply providing a service, so that we can get them more engaged in other type of activities that are required if you are about ultimately bringing about positive change for communities. So, but I like to link, this issue of the link between organizing and providing services to trends in funding that very often make hard, to actually practically reconcile the two. I can tell you that many of the small community-based organizations throughout the country have struggled pretty consistently trying to get funding to provide legal immigration services. It doesn't matter what town or what city we're talking about. It is across the board, and I think that it is great to build the scenarios that you guys have done. And I confess I haven't read the study yet, but I take for granted that everything there is going to be of interest to a lot of the people I work with. But I think it is important to note that the only reason why we didn't have more capacity at the get-go is because it's been really hard to get programs that were doing more or less what I was just describing actually funded, especially by philanthropy, because they tend to view services for some reason, as not so deserving, of support. And aside from these comments, I did want to ask from the panel, DACA was announced in the summer of 2012, and it went through. And it was implemented and continues to be implemented in its original fashion. DACA Plus and DAPA were announced in November. What would you say in explaining why these two programs fare so differently? Meaning one did went into effect, the other two much larger than the original did not. What's the explanation that you guys can give us?
Yeah, I don't know if I have a good answer for that. On your first point, I absolutely agree regarding the funding, and I think that is a big reason why CIRI's work is actually really critical in this area, because we have been able to make inroads and have really frank conversations with funders about what the needs really are in terms of legal services and why those individual legal service programs and individual Board of Immigration Appeals representatives, that work needs to be funded. I don't know. I really don't have a good answer for that.
Yeah, just 2 points. One is on the, in terms of politics, the other guys get to play too. So the DACA 1 was challenged. Actually, that case is still in the courts, although one of those cases has been dismissed. Better lawyering, and they got the right judge, and they get to forum shop just like we do. So I think this fee questions, the multiple roles questions, I don't disagree in the abstract that it'd be great if more groups were doing both. It'd be great if actually one set of fees could subsidize activities in other areas, and this is not something you mentioned, but I think you were going towards it. I know Centro Presente used to do this, which is to charge membership fees that also, in effect, subsidize the legal services operation. I don't think the question is really just a matter of funding, nor is it just a matter of philosophy in the abstract, but there's a reality too. I mean, you were one of those people who could walk and chew gum and do other things all at the same time. Not everybody can do that. So, I think those in the service field, regardless of whether they may or may not have turf issues, do have a legitimate point about demanding and expecting high quality service as an ethical responsibility to the field and to the people they're serving. And, for some groups, it's not easy to do that and to also be a great organizing and advocacy organization. This from an organization that we try and do both at the national level, not always so well, and we encourage our affiliates to do the same. One other side point, I would also say this is not just a challenge for the external funding community, the major nonprofits. There are over 50 million Latinos in this country. Not all of them are poor, not all of them are immigrants. All of them contribute to the church, just about. I think there's a role for their support. We have lots of organizations in the Latino community and others that have assets. Many of them deployed those assets during IRCA and during NACARA and other eras, and there's no reason why they shouldn't be deploying them now.
And I would say too, at least going back to the organizer-lawyer kind of dichotomy and what I was talking about earlier, my career has clearly not been as long as Charles's, but I will say that
Is that a shock?
No, not at all. Just means I have less experience and less knowledge, but in the length of the time that I have been working at ALIN in this field, I will say that I really think that there has been a shift and a lot of positive strides towards working to understand each other and working together, and I think that has a really big impact on organizations even internally. I mean, it's hard because lawyers will say, I can't have my client go to the media. What if they say something that's going to prejudice their case? I have to be a zealous advocate. I have to protect them. And that's, part of our training. It's part of our license. It's part of our ethical obligations. And all of that is true. But you also have to, as Courtney talked about earlier, let the client be the one to make that decision and to empower themselves. And I think lawyers are getting a little bit better about that. And a little bit more open to it. And if I can see it over the course of 8 or 9 years, I'm hoping that as we go forward that it's going to continue, to get better and better, and will be have positive implications for, legal groups and non-legal groups, but also organizations like NCLR that are providing both of those services. And the dreamers know how to do it. So we should all take a page from that book.
So from what I understand, the basis of this is trying to see where we can go forward with what we have and kind of categorize where we can save money, can't save money, and work with forward from that. So one question I have, especially from the persons survey study, because the 25% of the people who are currently not documented could be eligible for the U visa, and then there's 70% others. So I'm going to just guess that some of them could qualify for the T visa. So in terms of using resources that are already funded by the government, I'm just curious how much positive interaction you have with the police being able to appropriately identify UNT or possibly eligible for UNT visa people, and how that's worked with organizations that work with people and also with lawyers, because if you have the ability to be recognized initially as a potential candidate for that, there's so much time and money saved. And if you run into that at all in your research and what you think can be done to improve upon that.
I know that there has been a lot of work in that area, specifically in the domestic violence shelters and programs there, and I'm kind of motioning towards Jack because he has done a lot of work in this, and getting them recognized, and he's not getting up at all. But there has been some work in that, and there was a small amount of funding for that, and over a decade, I know that Clinic worked with, I think it was 50 programs that then became recognized and accredited, and a lot of them do focus in those areas. I am not the expert though.
Expert, come to the
Well,
mic.
the expert is being very coy, but would you please walk up here, expert? And it's not just, it's also training law enforcement, you know, I mean, there's an awful lot of that goes on to identify survivors of trafficking.
Yeah, the Catholic Legal Immigration Network was fortunate enough to get some assistance from the Department of Justice starting in 2006. It hasn't quite been a decade, to develop this nascent capacity of domestic violence shelters to do immigration work, because of course the domestic violence shelter advocate is a highly trained professional who deals with issues much more grave than what immigration advocates deal with, because frequently it's life and death matter. They're perfect people to do this because they do a lot of case management, etc. And so all we did was to facilitate them getting the training and experience and know-how to become Board of Immigration Appeals accredited representative so they could do this. And at this point, we've had the great honor and privilege of helping in excess of 50 groups all over the country. And in fact, I know one of them is the poster child at the Board of Immigration Appeals for Board of Immigration Appeals accreditation recognition, because it's a little domestic violence. It's actually a family justice center in it's in Sweetwater County, Wyoming, at the lower southwest corner, Rock Springs, Wyoming. Okay, and if you're a domestic violence survivor in Rock Springs, you can either ask the person who beat you up the night before to drive you to Salt Lake City, 2 miles to the west, or ask him to drive you to Denver, which is 3 or 3.5 hours. So that's not going to happen, right? So that service has to be available for the domestic violence survivor right there in Rock Springs, which it is now, thanks to this wonderful funding from the Department of Justice and my colleagues at Clinic who've done all this wonderful training people and given them this tool to put in their domestic violence counselor toolbox. Since we see a lot of people coming forward to do this, we have a dream that when we get administrative relief here shortly, we'll be able to find funders who will give domestic violence shelters a lot more money so they can hire staff who just do this and who go after all the other women in the community to help them get status, because as we know from the studies, the intimate partner immigration status disparity is a slippery slope that can lead to domestic violence. So this would be a wonderful thing, because we'd be able to sort of level that playing field and do a lot to eliminate that cancer in all of society, and also it is in the immigrant community. Thank you. Great question.
If I just might say something quickly here, and Oscar's comment on the lack of funding for legal service programs I think is very telling and true. In you know, if it's true that, say, 20% of the unauthorized, and Charles's point that people are overextended is certainly true as well. But if it's true that 20% of the unauthorized are potentially eligible for something that would put them on a path to citizenship, which we think it is, and the person survey was 14 to 15% of the people screened at DACA intake sessions, and we think that that screening in a lot of cases was probably pretty cursory. The other statistic that we didn't promote that much was that 56% of the people that come in and get screened during normal office intake hours at legal services offices around the country, 56% of them have case files open for them, which means that they potentially have some kind of legal relief or benefit available to them. So that's a pretty significant number. But the point is, there's likely, you know, a couple of million, maybe 3 million people, who knows, unauthorized, that could become legal if only there was legal services funding, if only there was capacity building funding up front, and that it really needs to happen. You know, it's not enough at this point to say that it's just money that goes down a black hole that doesn't affect major policy change. We're looking potentially at a program, in my opinion, that would be larger than a DACA program, and we don't have to wait for the courts and we don't have to wait for Congress to do it. And it's been a little bit confusing to me. I mean, I know why the groups aren't doing it, because they don't have this kind of capacity and don't have this kind of funding, but why it hasn't emerged, I'm not 100% sure, because it's a legalization program waiting to happen.
My name is Michael Jung with the Four Freedoms Fund, and I guess from the funder perspective, even thinking about administrative relief and moving forward, I think initially there was a lot of excitement, you know, ideas about innovation, how to use technology, how to have service-to-base models, how do you connect legal service providing to organizing and advocacy and such. But then I feel that that excitement is starting to kind of die down. And I'm wondering from your guys' perspective that, you know, as administrative relief and beyond, the different scenarios that you maybe have thought about, what are the possibilities? Because we're still trying to fund, well, we still do fund a little DACA work, but overall the AR money or the different types of funding that were initially brought forward, a lot of it just because of the way the courts have been working, it's just, you know, I think that a lot of the funders are just like, no one wants to move forward and no one wants to take the lead, and there's too much uncertainty, and just wondering what you guys think about the different scenarios, and like, yeah, I wish I had a better way of forming the question. I think that it's just too much uncertainty, basically, and I'm wondering what would you recommend to be the next step since?
So I think that's an interesting question, and I would turn it right back around and ask you, why do you think that, I mean, other than the uncertainty, yes, there's uncertainty, but it's always been that way in this field, right? So what quashed the excitement? Because as Don was just saying, there's still a potential for this 25% of the 11 million who could benefit from an increased capacity right now today.
Plus, and I might add, plus the people that haven't come forward with DACA, the other groups that Charles mentioned too, plus the DACA renewals, you know, on and on and on. I mean, there's several groups. We can get up to more than 25% pretty easily.
And from a funder perspective, what messages do you need to hear from us in order to encourage that excitement level to go back up again? Because I think we're not doing a good job with our message if that is the reality of the philanthropy perspective.
Yeah, I would definitely agree in the sense that the actual numbers of what is the potential, what can we actually, the number of people that can actually be helped, that is not completely clear. And secondly, just the people that come to the table. So maybe like GSIR or different funding collaboratives, everyone comes to the table with a different goal in mind. And so a lot of the funders, like was mentioned earlier, they're just not legal service providing funders. That's not what their mission was coming into it. That's not the way that they did grant making. So, you know, this other side appealed to them, but maybe that's, you know, that's not the case anymore. And
I hear that, and I guess in the short term, there are a couple of scenarios that are pretty clear. So one is that we get a favorable litigation calendar and a favorable decision, and sometime next year we have the, you know, implementation of what we thought would happen, you know, early in 2015, earlier this year. You know, I do think there are a couple of other scenarios we might think as a stepping stone for the longer term. So one of those is there has been some funding, it's not enough. Clinic and ILRC and World Relief and a range of others are ramping up their training and other support for, you know, for building the field. A lot of organizations are testing, and we hope refining community navigator and other cooperative models and mass processing models. So I think the answer is, so if the implementation of something like DAPA and expanded DACA is delayed, at a minimum we ought to be somewhat better positioned than we are now. And finally, if nothing happens on the AR side, quote unquote, for the next couple of years, with the work that's already being done, and frankly, just a little modest injection, I mean, far short of, I think, what we had of the, you know, 80 or $100 million we had hoped, I think the funders and the society would get a very substantial return on that investment, precisely to address the numbers of people we're talking about in terms of existing DACA and people with other remedies. So in terms of scenarios, those are the ones that seem obvious to me.
just
Jack,
last, so outside of AR, what kind of potential do you guys see of numbers? So you guys are still saying that the 25% that.
I would say, you know, so when this paper was written was before the New York mass processing effort took place that Don referred to earlier, which came up with that larger, arguably 25% or more number. It was before the publication of the 601A waiver, which in a rule which in a kind of weird way I think is going to expand demand and access to family visas. So my personal belief right now is the 1 million or 2 million number we've been throwing out as potentially eligible for other forms of relief is almost certainly significantly higher if we had the capacity to serve them and if we had a communications effort to match that capacity so we can reach those folks to encourage them to come forward and get screened. Jack, you were going to add something?
And can I just, yeah, I'm sorry. I'd also say that the point I was trying to make at the outset is this is work you're going to have to do anyway, right? I mean, this is good. If DACA and DAPA happen tomorrow, you're going to have to screen people for other relief, you know, because those are temporary programs. So why not start now? And you're going to benefit a lot of people by doing that.
Yeah, I just wanted to sort of say that actually, you know, this is our silver lining, this delay from the lawsuit, and I don't necessarily see a lack of enthusiasm. I see the state of California stepping up with $15 million. I see CIRI, the tremendous work that CIRI's done. Our latest graduating class from this amazing 60-hour online course that we're doing that will basically help people get Board of Immigration Appeals accreditation at their recognized agencies. Yeah, I've seen the initial numbers. We're graduating somewhere in excess of 225 people. If every one of those goes and gets through an agency, community-based agency that has recognition, accreditation, as Courtney knows, since she does this on a daily basis, as Michelle, as a BI credit rep, knows, this will be the largest increase in immigration legal services capacity in the United States in that span of time. So, and what are these people going to do? I can tell you in California, you know, to put my Catholic hat on, they're going to participate in the Parish Pilot Project, which is 11 dioceses are having Catholic charities manage a lot of these people as volunteers in their parishes under the supervision of a BI credit rep doing screening. And I would respectfully take issue with my colleague, Charles Kamasaki, who said that he thought it was a bit false to do the screening, identify a remedy, and not be able to provide the relief, the capacity. I'm hopeful that funders, and you know, many of my friends are at that GCIRI table, will step up and fund that. And even if they don't, I think someone is better positioned if they have that knowledge. Some guy said knowledge is power. I forget who that was. But if the person, the immigrant out there, the undocumented person knows that there's some hope up the road, I think they're in a better place than if they don't know that. And so I think it's very much worthwhile for things like the Parish Pilot Project in California to have all these parish level volunteers get accredited and be able to do group processing, group screenings for free for their parishes under the supervision of Catholic Charities staff, and be able to unearth for people, well, you know, you've got this going on for you, and the counterbalance of that, to know that they don't have something going for them, so they won't get taken advantage of by an unscrupulous, unauthorized provider, as one of you mentioned. So I see a lot of hope. I also see this as these things that are being tested, the massive training. You know, 200 people, that's the biggest we've seen in terms of an increase. It's not enough, as we've just learned from our panel, our very excellent panel. But it's a model that we can take to scale. So this is, we've used this time well, we are using this time well, we are testing these things, and we will be ready when we get to AR and then beyond to CIR. So I think I'm sorry to hear some of the funders are a little you know, disappointed or giving up or suffering from what I call sometimes funder ADD. I didn't say that. I did not say that. You want to respond to this?
Yeah, I just want to make sure.
I was afraid of that.
You know, I'm in no way speaking on behalf of national funders anyway. I just know that there was an initial wave of funding and excitement, and with the holdup, it's just people want to wait and see. I imagine that's the scenario. And so, from your guys' perspective, but yeah.
So you're very good to raise that. Thank you for bringing that up. And
can I just respond to Jack?
The response? No, you can't. Of course. But our response to that is don't wait and see.
Yeah, just to clarify, I was not making the point that it is not a good that it's a bad thing for people to come forward and screen. The point I was making that many nonprofit providers are reluctant to invest in screening if they don't have the capacity to follow up, and I just think that's a truism in the field.
Well, yes. Well, we have one more person behind you there.
You know, providers, do we need to be ready? But the people need to be ready. The people need to have been screened. The people need to have all of their documents, right? And a lot of those times it means what? Having to get a FOIA from CIS to figure out what their immigration status was or what their immigration history is. And that takes about 6 months. So if this happens, and the most optimistic of timelines is in June of next year, if people are not ready, we only have a short window of time between June and December of next year, right? And if people are not ready with their application and all their documents, then what's the point of doing everything that we're doing if we haven't helped those people who qualify to be ready on the day off? So it's not that we can start doing screenings the day that DACA Plus and DAPA start. We have to have people ready to apply the day that happens, and for that, we need all this time to start helping people right now. I would say that's one thing. And the other thing that we haven't mentioned, we talked about U visas, T visas, there's SIJ, the Special Immigrant Juvenile Status. A lot of kids qualify for that, but don't know about it. And that's very resource intensive. And that requires a lot of money because you have to go to family court, then you have to go to immigration court. And so those are people who could be getting a green card, but they don't, and they age out. So we don't have the privilege of saying, let's wait till somebody gives us money. If they age out, they no longer have a green card, right? So there's a lot of services that people can be getting right now to get a green card right now to then become voters and be able to have a voice in the system.
I just wanted to add one more angle to why it's so important to have ongoing capacity. A lot of people, immigrants I'm talking about, they are desperate to try to find a solution to their undocumented situation. If they don't have a reliable organization to go to, or a reliable organization that comes to them, to bring them education, to bring them access to services, what they usually do is they go to whomever is selling them a lie and end up in the hands of a notario, and 2 years down the road, they are in deportation proceedings. And that's pretty bad, and so that's a very important reason why increasing capacity to do more education, more direct service in the legal immigration services field is so crucial. So,
I wonder if you all would like to say anything in closing, kind of any final thoughts? Anything we haven't covered? No? So let me first of all, thank you for those terrific questions and those terrific interventions. I feel that the last two comments were great summary comments, so I don't, and thank this group for working so hard over so many months, overcoming such adversity to produce this paper, which I think is going to be a staple and a mainstay in the field for a long, long time. So thank you for doing it. It's an important paper. For those of you who are listening to us, please read it and please spread the word about it, because it's a terrific reference. And congratulations to CIRI for all of its terrific work as well. So thank you.